All right. Let us continue our discussion on intellectual property, this time focusing on trademark. Okay. Now, following the syllabus prescribed for the 2023 bar examination, trademark law starts with the definition of mark, collective mark, and trade names. Okay. Now, mark is the generic term for any visible sign. So this is a sign that can be seen, okay, using our eyes. And this sign is to distinguish goods, okay? If it's for goods, so this is for trademark, and service or service. And this is service mark, okay? And this include any stamp or mark container. So, in short, the container itself is a trademark. Kasi nga naman, pag nakita natin itong bote na to, right? So, nakita natin itong bote na to, then um, we we immediately would say that this is the brand that we are actually wanting to buy. Okay, so yun yung stamp container. Okay, now what about a collective mark? A collective mark is also a visible sign. Okay, ito yung nakikita dito, visible sign. And the purpose of this visible sign is to distinguish origin of several products or goods or services, or to distinguish common characteristics. Okay? So, collective mark, kaya nga siya collective, it presupposes that this mark is used by several goods or services. Okay? If the visible sign is to distinguish the origin, for example, Unilever. Okay? So, lahat ng may tatak na Unilever, lahat ng produkto niya, then we know that the origin is this company called Unilever. Common characteristics. Okay? So, I think a good example for this is yung pag mag-shopping tayo, mag-grocery tayo sa SM. Meron silang SM bonus. Okay? I think yung SM bonus would point out the common characteristics of those goods na may tatak ng SM bonus, which I think is the lowest price in their respective category. Okay, so pag nakita natin yun, ito yung sinasabi ng tindahan sa atin that ito yung pinakamura sa category na ito. Okay, so and this pertains not only to a specific product but for several products. Okay, all right. Now we now go to trade name. Okay, so earlier in our discussion, when we introduced the topic intellectual property rights, okay, we mentioned that ito namang trade name na to is a name to distinguish the business or the enterprise. Okay? So, trademark for the goods, service mark, collective mark, origin or common characteristic, and the trade name is for the enterprise. Okay? Now, so trade name. Okay? How are trade name acquired? Okay? Or uh, paano ba magkakaroon ng trade name? Okay? So it starts with um, applying sa Department of Trade and Industry. Okay? But if the question is, does it require registration under the Intellectual Property Office, under the Intellectual Property Law? Trade name is protected even without registration. Okay, and this was illustrated in the case of Coffee Partners Inc. versus San Francisco Coffee and Roastery Incorporated. So the gist of this case is whether the San Francisco Coffee may be used by another company despite the another company using this as a trade name. The allegation or the contention of the other party was that this was not registered, hence it cannot be protected. The Supreme Court did not agree, saying that under the intellectual property law, as worded right now, it can be protected even without being registered. Okay. Another important case insofar as this topic is concerned is the case of GSIS Family Bank, a thrift bank versus BPI Family Bank. Okay, so GSIS Family Bank, obviously it's using Family Bank, and BPI Family Bank oppose the usage of family, saying that they should be the one only using BPI, the term particularly family bank. GSIS said, no, this is not registrable because family is a generic term. The Supreme Court did not agree that family is generic in this sense because family has nothing to do with the bank. Okay, so this is a coined phrase capable of being registered. Okay, but that is not the reason why this is important insofar as our topic trade name is concerned. The relevance of this is the contention of GSIS Family Bank that the Bangko Sentral ng Pilipinas has agreed that GSIS would use this name GSIS Family Bank, a thrift bank. The Supreme Court said, no, it's not the BSP that has the authority, the jurisdiction to permit a company from using a corporate name. This is actually the corporate name of this company, this bank. It is the exclusive jurisdiction of the SEC, and the Corporation Code or the Revised Corporation Code of the Philippines would say that the corporate name, for it to be approved by the SEC, is something that must be distinguishable. Okay, and that's the importance of this particular case. Okay, now let's go to trademark. Okay, the question now is, how are trademarks acquired? It was clarified in the case of Zunica. Okay, the case of Zunica Pharmaceutical versus Natra Farm. That trademark are acquired through registration. Okay, and this is an important case. This is a 2020 case. In fact, it was asked in the 2022 bar examination. Okay, so posible pa rin mag-create ng mga tanong dito sa Zunica case na to. This is an important case because this case clarified a parang we can call it confusion as to how trademarks are acquired because there was a previous decision made by the Supreme Court that trademark is a function of use. At kapag ginamit mo to, pwede mo na siyang iparegister. In other words, companies, for the companies to be allowed to register this, they must be using the mark. Okay? Now, kung mare-relate natin ito sa patent, di ba? I hope natatandaan nyo, no patent, no protection. So, for patent, it is registration that is primary to patent. Now, ang dating rules sa trademark, emphasis sa use. But in the Zuniga case, the Supreme Court clarified that as worded, no, ang textual, ang text ng batas natin sa trademark is marks are acquired also through registration. In the Zuniga pharmaceutical case, okay, the case was about the use of synapse. Okay, of the petitioner Zuniga and synapse with an E of the respondent. Okay? These are both medicine. Ibang sakit nga lang ang para sa itong gamot na to. This is for epilepsy. This is for cerebrovascular disease or stroke. Okay? But nevertheless, both parties agree that these are confusingly similar marks. The question in this case is, sino ba ang magkakaroon ng right over the mark? Is it the prior user or the prior registrant? Had it been decided under the previous rule, it will be the prior user that has the right to register. But in this particular case, the Supreme Court clarified that it is the prior registrant that has the right to the patent. Okay? So that was asked in the previous bar exam. So I think ang mga pwedeng question dito is wala na bang gamit yung use if that's the case? Okay? Answer, meron pa rin naman. Because under the trademark law, if you are the registered owner of the mark, you need to use the mark. In fact, there are formalities, yung declaration of actual use must be filed within a certain period. Okay? Otherwise, madidim abandon yung registration. So, use is important in order to maintain ownership. Okay? To maintain ownership of the mark. Now, what about the prior user? Like in this particular case, supposing that the petitioner is a prior user and the respondent is a prior registrant. And supposing that the court ruled that it is the prior registrant that has the right to the trademark. Does it mean that the prior user is now prohibited from using their brand or their mark sign-up? In this case, the Supreme Court said that no, they are not. As a prior user in good faith, the petitioner in this case may still use the mark sign-ups because it's a prior user in good faith. Okay, so those are the two things that might be asked as a follow-up question to the 2022 bar exam question. Okay, so maintenance of ownership and the limitation in trademark law, which is prior user. Right? Now, important also is the topic non-registrable marks. Okay, this is section 123. Okay? Now, so Section 123 is composed of several paragraphs. Okay? Now, each paragraph contains more than one non-registrable mark. For example, under Section 123, paragraph A, or the first paragraph, okay, so marks that you cannot register would be those marks that are immoral, deceptive, scandalous, and those that may disparage, paninirang puri, okay, sinisiraan mo, or those that will falsely suggest connection to a person who is either living or dead. Okay? And in one case, in the Fredco case, no, Fredco versus Harvard fellows, person here is clarified not only referring to a natural person, it may also refer to an artificial person. Okay? So if you are using a mark na wala ka namang, if you are using the person's name, na wala ka namang connection doon, then that is not registerable because it falsely suggests connection. So if the mark is immoral, deceptive, scandalous, or would disparage a person, these are also not registerable. Paragraph B would be marks that are consist of flag, okay, or coat of arms of the Philippines, or any of its political subdivision, and also of foreign nation, or any simulation thereof. So this talks about national symbols which are not registerable as a trademark. Letter C would be any name, consists of name, portrait, or signature, right, of any living person. Okay, so the person here must be a living person, and you may use that person's name, portrait, or signature only if you obtain the consent, the written consent of that living person. Section C is also includes the deceased president. Okay. Now we cannot use the name, portrait, or signature of a deceased president except all right. Deceased president. Again, we are still talking about uh, paragraph C. Okay. So paragraph C, okay, talks about the name, portrait, or signature of a living person. Okay, we cannot use the name, portrait, or the signature of that living person unless we obtain the consent of that person. Now, paragraph C also includes the president, a deceased president. Should we want to use the name, portrait, or signature of the deceased president as a trademark, we can be allowed to do so, provided that we get the consent of the widow, okay, or the widower, as the case may be, okay, as long as we get the consent during the life of the widow, okay. Now, supposing that the widow is already dead at the time, okay, so supposing that you want to use the deceased president's name and the widow is already dead, may remedyo pa ba? Well, under paragraph C, it was not mentioned that you can obtain the consent of the descendants or the heirs or the estate. There's no such mention. So, wala na bang remedy? I think may remedy pa din. But the remedy is no longer under paragraph C, but under paragraph A, yung falsely suggest connection. Such that you want to use the name, portrait, or signature of the deceased president. So, but the family would agree. Right? So, pwede tayong pumunta dito because your use of the name, signature, or portrait of the deceased president is allowed because it no longer suggests or falsely suggests connection. In fact, meron naman talaga ikaw connection because pumapayag yung estate or yung tagapagmana or yung family. Right? As long as it will not be scandalous or would disparage the name of the deceased president. Of all the paragraphs here, it is actually paragraph B, I think, the most important. Kasi napakaraming case dito sa paragraph na to. Okay? The case of the paragraph B is about non-registrable mark if the mark is identical. So, kaparehas. Right? Identical with a registered mark. Okay? So, let's say, for example, gusto mong magnegosyo and you want to use a mark that is identical with already a registered mark, then you are not allowed to do that because that will even constitute trademark infringement. Okay? But let's say, for example, just for the example lang, so we are all familiar with this mark. Okay? So this is a Nike trademark, right? So all shoes that we see this mark or shirt, we know that it is from Nike. Supposing that you want to use this mark, sorry sa drawing so more or less parang mukhang Nike trademark. Pwede ba under paragraph B? If you will read closely paragraph B, parang pwede naman. Kasi ang sabi doon, identical with the registered mark in respect of same goods or services, such that if you want to use an identical mark, right, but you will use it for a different goods, then you are allowed. Okay, and this will bring us to some of the cases decided by the court. The case of, let's say, Anaang versus Teodoro. I think this is a staple case discussion in the intellectual property law. Teodoro is the proprietor of Ang Tibay. Ang Tibay for shoes, okay? Slippers and baseball cap. Okay? And it's a success story. And Anaang would want to use Ang Tibay for her business, and she is selling shirts and pants. Okay? Now, the Supreme Court said Anaang cannot use Ang Tibay because it's an identical mark with Teodoro's Ang Tibay. And the reason why the Supreme Court said that Anaang cannot use this because shirts and pants are the same, similar goods with shoes. In another case, in the case of Mighty Corporation versus E&J Gallo. The issue in this case is whether Mighty Corporation can use Gallo for their product cigarette, because E&J Gallo is using Gallo for their wines. The court said this may be allowed because cigarettes are not similar with wine. Okay, so the reason why we need to discuss this because madali tayo magkamali dito, right? Because if it's identical, then we will automatically say that this cannot be used. But it is clear from the law that only in respect of same goods or services. Another mark that is not still under paragraph B is when the marks may not be used for similar goods, but it is used for closely related goods. Okay. Now the question now is what we mean by closely related goods, and there are cases that we can use. Okay. For example, the case of UFC Philippines versus Fiesta Barrio. Okay, so this is a 2016 case. Of course, I think we are all familiar with UFC, okay? Barrio Fiesta. So, they are the issue in this case is whether this Barrio Fiesta manufacturing can they be allowed to use Papa Boy ketchup, right? Because UFC is selling yung Papa ketchup, and Papa Boy is also using this for their lechon sauce. Well, they may not be the same, but they are closely related goods. The same with the case of Mang Inasal, Philippines versus IPF Manufacturing Corporation. Okay, the issue in this case is whether yung produkto, of course, we are all familiar with Mang Inasal, right? And so, I think nakikita naman natin doon na laging maraming tao, right? Now, this company is selling snacks products na inasal flavored. Inasal flavored. Okay? Now, the Supreme Court did not allow them to use their trademark because they sell while they are not in the business. It's the same as Mang Inasal, because diba, Mang Inasal is a fast food chain. These are snacks products, yung parang mga cheese curls, mga ganon, right? But they are selling inasal flavored curls, and that, according to the Supreme Court, well, not the same, but these are closely related. Okay, so if you will read this particular case, the Supreme Court made mention in that particular case how can we determine whether what are the indicators to say that goods are closely related. Okay, now let's go back to paragraph B. So again, just to make a brief recap, okay? So marks that are not registrable under paragraph D is when identical, it's an identical mark with already a registered mark, but only with respect to the same goods or services, or if they are used in respect of closely related goods. Another mark that is covered by paragraph D is when the marks are not identical. However, it nearly resembles such a mark. So yung such a mark dito, it pertains to a registered trademark. Okay? So kung gagamit tayo ng mark, not identical, but a mark that nearly resembles such registered trademark, then we are not allowed if such use will likely cause confusion or deception. Okay? Would likely deceive or cause confusion to the consuming public. Okay? Now, with respect to this, okay, better to discuss the types of confusion. There are two types of confusion: confusion of goods and confusion of business. Okay? Confusion of goods is when a prudent, right? Maingat naman sana si prudent buyer, but this buyer bought a good or a product which he believes or she believes that this is the product that sold by the plaintiff. Okay, so let's say, for example, A is a prudent buyer and A bought X because he thought that X is the goods of the plaintiff. Okay, so the plaintiff is selling goods X, but the defendant is also selling a product na pinackage niya as parang X. Okay? So, A thought that this is the product of the plaintiff when in fact this is the product of the defendant, and A got disappointed because of the low quality of the product that he bought, which he thought that it was from the plaintiff, and this of course will prejudice. It will reflect the it will reflect on the plaintiff's reputation. Now, confusion of business is when this buyer will buy a product. Okay? Hindi siya nagkamali sa produkto, but he bought this product thinking that this is the product of the plaintiff. Okay? Bumibili sila ng produkto kasi akala nila ito yung produkto ng kanilang pinagkakatiwalaang seller. But in fact, this was the product of the defendant. Okay? So in short, unlike in the confusion of goods, the intention of A is to buy a particular product which he thought is from the plaintiff, pero sa independent pala. In this particular case, the buyer bought a certain product kasi akala niya produkto ito ng pinagkakatiwalaan niyang negosyo. But of course, it was not, okay? And because of that, the buyer think that the plaintiff is selling low quality products, okay? And this is in other words, there is actually no connection between this product and the plaintiff. Okay, now it is clear in the law that if the mark nearly resembles, so we are not talking about identical mark, only a mark that nearly resembles such a registered mark that will likely cause confusion, then this is not registrable. What if in the litigation the argument of the defendant is that there is no actual proof of confusion. In other words, in the litigation, there was no offer of in evidence that people are actually confused. Would that be taken in favor of the defendant? Answer no. Okay, because the law is clear that actual proof of confusion is not necessary. Only the likelihood of confusion is required. Okay? Again, identity of the mark alone is not trademark infringement. Okay? Now, so in short, to summarize, okay? When the mark is a colorable imitation, okay, of a registered mark. So it is colorable imitation when it was an ingenious imitation, and this is calculated, right? Sinasadya to deceive ordinary persons. Okay? So, di ba, at a glance, may mga brands tayo na kilala natin, right? May mga trademark that we are all familiar with. Okay? And if, let's say, for example, there was this ingenious imitation na sa unang tingin natin ay parang brand na yun ah. Parang yun yung kilala nating brand. When in fact, it was not. Right? It was just made to make it appear that it was the brand that we are going to buy, but it was calculated to deceive us, then that is colorable imitation. If that's the case, then the use of the mark or the trademark should not be registered. Right? Now, let's continue with section 123. Paragraph E is another important mark because it talks about well-known marks. Actually, paragraph E and paragraph F are both for well-known marks. Okay, but for paragraph E, well-known marks here are not registered in the Philippines. Well-known mark in paragraph F, these are registered in the Philippines. Okay, now what are well-known marks? Okay, well-known marks is when a mark is determined by a competent authority to be well-known mark. Okay, competent authority, of course, the courts, Intellectual Property Office, the Department of Trade and Industry. So these are examples of competent authority. So hindi porke kilala natin yung mark, it's a well-known mark automatically, right? So it must be the competent authority that would declare such. In fact, there are marks that are not known to us, ordinary consumers, but let's say, for example, the relevant sector would know the mark, then they may also be considered well-known mark. Now, common sense will tell us that well-known marks that are not registered are protected lesser than a well-known mark that is registered. In other words, may extra benefit yung mga well-known marks that are registered. Well, the benefit is if a well-known mark is registered, the protection extends to not similar goods. Okay? If the well-known mark is not registered in the Philippines, the protection is only for similar goods. Okay? So, example na lang. Let's use Rolex as an example of a well-known mark. Huh? But there was that case. Okay? May kaso na na-involve ang Rolex dito. The case of 246 Corporation versus Honorable Daway. Honorable Daway. Right? So the issue in this case is whether 246 infringed the mark of Rolex because 246 Corporation was using Rolex for its business family KTV. Okay, of course, family KTV is very different from Rolex. Now, the Supreme Court in this case said, Judge Dawal, we cannot decide the case. The Supreme Court cannot decide the case because facts must be determined. And of course, the Supreme Court is not a trier of facts, right? And that's the reason why the Supreme Court remanded the case to the trial court in order to determine facts. And what are the facts that must be determined? Number one, whether Rolex is a well-known mark. And number two, whether Rolex is registered in the Philippines. Okay? Because if it's a well-known mark and if it's registered, then even if family KTB is not similar to the brand Rolex, no, to which na Rolex is known for, of course, timepiece or premium watch, yeah, then 246 Corporation will not be allowed to use Rolex for its family KTB. But if it's a well-known mark but not registered, then it's possible for the court to allow 246 Corporation to use Rolex for its business that is not similar with Rolex. Right? So that's a well-known mark, okay, for paragraph E and paragraph F. Now, letter G under section 123 is when the marks is likely to mislead the public, okay, as to the nature, quality, characteristics, or geographic origin of the goods or services. Okay, so any mark that would mislead the public insofar as these things are concerned, not registerable. H is when the mark are exclusively signs that are generic or descriptive. Okay, descriptive. Generic is when the mark is generic to all products. Okay, generic to the product that the mark they are using. Okay, so that is not that will not be allowed. Okay, letter HI when the mark consists exclusively of signs or indications that have become customary to designate the goods. Okay, so customary, ito na yung tawag natin sa mga goods na yan. Then it is not registerable. Letter J is when the mark consists exclusively of signs of indications in trade, okay, to designate the kind, quality, quantity, intended for origin, geographic indication or origin, okay? So these are marks that are not registerable under paragraph J. Under paragraph K, consists of shapes, okay? Not registerable. Letter L consists of color alone. not registerable, and finally under paragraph M, when the mark is contrary to public order or morality, not registerable. Okay, so these are the marks that are not registerable under section 123. There are so many cases that that were decided by the court. So as compared to trademark and copyright, it is in as compared to patent and copyright, rather, it is in the law on trademark that the court has made so many cases. Okay? Now, let's discuss now the two tests. What are the two tests to determine whether the marks are confusingly similar? Remember yung paragraph 3? Right? And the two tests are dominancy test and letter B, holistic test. Okay? Dominancy test is when the confusion happened because the dominant feature of the mark is present in both marks. So let's say, for example, this is mark X and this is mark Y. The dominant feature of the X is, let's say, this overarching M, and Y also included this overarching M in its logo or in its trademark. So the dominant feature are both present, and people might be deceived that this is also the product of X. Now, holistic test, right? Holistic test is when confusion results because of uh, the the general appearance of the products, including the packaging, the labeling, the color of the label, the color of the text, right? So if in the first glance, this particular product looks like this, okay, so this is X, this is Y, and let's say, for example, this X trademark is colored green with red. The letters are white in Gothic form. Okay, the material for packaging is plastic. Okay, and the bottle is this shape, and Y contains almost the same. Right, the color is green and red, right? The letterings are white, the bottle shape the same, right? So at the first glance, people might think that this product is the same as X. So this is holistic. Now, very important is that in the recent cases, particularly the case of Taiwan Colin, okay? Taiwan Colin case, the Supreme Court said that there is this judicial preference to dominancy test. Okay? So in short, the Supreme Court was actually saying that this may be abandoned. Okay? The case of Taiwan Colin, yung holistic test been abandoned, okay, because of the judicial preference to the dominance test. All right. Now, if the trademark has been registered, okay, what are the rights that are conferred to a registered trademark? Just like the law on patent, registration of the mark will grant exclusive rights. Exclusive rights to prevent third parties from using in the course of trade the said trademark, right? Without the consent of the trademark owner. So just like the law on patent, it grants monopoly over the trademark, right? Now, what about the duration? The certificate of registration is valid for 10 years. Okay? Is it renewable? Yes, it is renewable. What about patent? We mentioned that patent is for 20 years, but this is not renewable. Okay? So for trademark, pwede yang ma-renew perpetually. Okay, and this is the reason why Coke, for example, ilang taon na yan, right? So, walang pwedeng gumamit ng Coke except that particular company because it's a registered trademark. Okay, and they have been renewing the Coke brand. Kasi nga naman, napaka-importante ng Coke brand na yan. Right? I think it's one of the most recognizable mark globally. Okay, now, license contracts. Okay, so just like in the law on patent, pwedeng mag-licensing contracts. And I think very recent we have been introduced to the concept of franchising. Right? Let's say, for example, there is this business na na-establish niya na yung kanyang buong operation. Okay? And yung ibang gusto magnegosyo, kukuha ng franchise so that they can operate the same with this franchisor. Okay, the franchise C may operate using the business name, right? Parang turnkey na lang, di na sila mag-experiment. Right? So I think that is a good example of licensing contract. Now, what about cancellation? Is there also cancellation in trademark, the same as patent? Yes, there is also the remedy of cancellation in the law on patent. Okay, and this is done by way of a petition to cancel the registration of a trademark, and this is filed with the Bureau of Legal Affairs. Okay, now the rules is that the petition must be filed within 5 years from date of registration. Okay. However, if at any time the registered mark becomes generic name, okay, then it may be filed anytime. Okay, may be filed anytime. All right. Now, we mentioned about the use. Okay, Section 152 actually talks about the effect of non-use. Okay, so if let's say the registered owner is not using the mark, okay, will that cause the cancellation of the registered mark? Answer to that is it will depend. It will depend on whether the non-use may be excused. Okay? And Section 152 is clear that if the excuse being offered by the registered trademark owner is that they lack funds, kaya hindi nila mapagpatuloy yung business because of lack of fund, and that is not a valid excuse. Hence, it will cause the abandonment of the trademark, and the trademark will now be open for everyone's use. Okay, so if you will be asked a question on this, check if the facts of the problem would grant would give you a basis to say that like excusable yan. Like for example, like pandemic, Okay, so matagal hindi maka-operate, etc., etc., then that may be excused. But insofar as the pandemic reason is concerned, di ba, medyo nagduduwag na. So you also need to determine the time frame. Okay? 1 or 2 years, but let's say, for example, kung umabot na ng 3 years, 4 years, that may not be a valid excuse anymore. Right? Now, remedies. Right? When we talk about remedies, we talk about trademark infringement. Okay? So trademark infringement is when any person, without the consent of the registered owner of the mark, is using in commerce any reproduction, counterfeit, copy of colorable imitation. So ito yung mga nakikita natin, napaka-rampant dito sa tindahan, right? So we buy things kahit makikita natin mga well-known brands brands that we all know, tapos binibenta. Alam natin sa mall, ang presyo niyan 1,000, 2,000, 8,000, nabibili natin 500, 200. But of course, those are counterfeit copy. And those are subject to remedy against infringement. Okay? Now, so what about the limitations? Okay? So just like the limitation in patent, these are the defenses that the person accused with trademark infringement may use in defense para sa mga actions for infringement. Okay? Now, we mentioned that prior use, right, in good faith is a defense. Okay? So this is section 159. Now, other section in section 159 would cover, let's say, for example, a printer. Right? Kung, for example, may printer dyan na may nagpagawa sa kanya, nagpa-print sa kanya ng infringing mark, right? Yung first offense, mapaparusahan lang siya for injunction for against future printing. Same with a newspaper. May nagpa-advertise sa isang newspaper, counterfeit pala. Okay, so the remedy is only with respect to the future publication. Okay, pero syempre, pag mga paulit-ulit na din, ibang usapan. Okay, now, alright, trademark delusion. Okay, ano naman itong trademark delusion? Trademark delusion is when there is no infringement, no? Yung mark ay medyo iba naman. Okay? However, trademark delusion is when the use of another mark would lessen the distinctiveness of a registered mark. Okay? So there is no magkaiba, right? So I think the best case to illustrate this is the case of Levi Straw versus Clinton Apparel. Okay, so this is about the Dockers. Okay? This is the trademark of Levi's, and Clinton's is products. Malayo naman, right? So, but Levi's still sued Clinton Apparel because they claim that this is trademark delusion. Kung titingnan natin, this is not identical nor can be said, products can be said as tolerable imitation of doctors. But Levi was saying that this is a case of trademark delusion because it lessens the distinctiveness of their brand doctors. The Supreme Court, however, did not agree, saying that for this trademark delusion, it must be proven that the mark has been uh, recognized by the consuming public. Okay, in this particular case, Levi's failed to prove that recognize yung dockers na to, and their assertion that they made an research, right, that the mark is famous, but the Supreme Court did not accept uh, that evidence. All right. Now, there are other offenses in the trademark law, okay? Offenses such as um, use of uh, a mark that is, let's say, for example, false designation, okay? False designation of origin or false description, okay? So if the company is selling a product under the same mark, but it falsely claims origin. Let's say, for example, made in France, pero hindi naman pala galing doon. Then that is also a violation under the trademark law. Also, false description or representation. So a company selling shirt, sabi niya, made of 100% cotton, but it's not. Right? Then this is false description or representation. Now, let's now go to unfair competition. Okay, so insofar as the bar exam is concerned, I think this is more asked in the bar examination as the difference between unfair competition and trademark infringement. Okay, now the difference is that in unfair competition, this is mala inse, this is mala prohibita, meaning intent is necessary. Here, intent not necessary, because the offense in trademark infringement is the unauthorized use of registered mark. Okay, so the mark has been registered, you are using it even without the intent to deceive, to defraud, but because this is mala prohibita, then that is an offense. Mala in se is unfair competition. So an essential requisite of this offense is the intent to defraud. And what is the fraud here? Because in unfair competition, you are passing off, or you are selling, you are palming off your product as if they are the product of another. Okay? So, niloloko mo yung mga bumibili sa'yo. Alam nila, produkto yun ng, let's say, known companies like San Miguel, kung sino-sino pang mga food manufacturers, when in fact, they are not the products of San Miguel. You are merely passing off those products of San Miguel when in fact they are not. Then that is unfair competition. Okay? Now, here, registration of mark is not necessary. Now, in trademark infringement, the mark should be registered in order for this particular case be prosper. Okay? Without the mark being registered, then the trademark infringement case will not prosper. Right? So those are the important topics under trademark law.